Good day and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion among experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we're talking about ITC proofing your patent portfolio to help increase your odds of keeping knockoff products literally at bay. For inventors, the promise of the patent system is the exclusive right to exclude others from making, using, importing, or selling their patented innovation for a limited period of time. But how do patent owners actually enforce those rights, particularly when the copycat product is being manufactured outside of domestic jurisdiction? In an otherwise challenging time for rights assertion, the ITC, or International Trade Commission, can be one of the most impactful long-range weapons an inventor has in their arsenal for stopping patent pirates. The ITC is an administrative agency tasked by Congress with protecting domestic industries from unfair trade practices, such as patent, trademark, and copyright infringement that's connected with foreign imports. Born under Section 337 of the Tariff Act of 1930, the ITC has the authority to grant exclusion orders, which are enforced by U.S. Customs and Border Protection to block the importation of infringing products at U.S. ports of entry. Given that so many products in today's economy are manufactured abroad and then imported into the United States, the ITC can be an incredibly effective venue for patent owners to stop knockoffs from entering the world's largest marketplace. Much like its executive branch sister agencies at the Patent Trial and Appeal Board, Federal Trade Commission, and Securities and Exchange Commission, the ITC is a quasi-judicial, non-Article III entity with court-like functions that resemble judicial proceedings. Powers include the ability to conduct hearings, issue rulings, and provide legal remedies in resolving disputes to carry out laws passed by Congress. Unlike its evil sibling at the PTAB, however, the ITC has been a champion for innovation and property rights. The exclusion order remedy that the ITC can apply upon finding of infringement is a form of injunctive relief. As regular listeners of the podcast, and anyone who's tried to obtain injunctive relief themselves will know, this is immensely useful to inventors and patent owners because it can provide what courts no longer can provide in the wake of eBay, which is injunctive relief to stop infringers. And it's really fast. Whereas court-based patent infringement disputes can take several years to resolve, ITC investigations take about 12 months to reach an initial decision, finish in 16 to 18 months, and will not be stayed due to an IPR at the PTAB. You may recall from the news around last Christmas, or even from the Mossoff Minute where we covered it, that a much smaller company, Massimo, was able to leverage the ITC to prevent Apple from importing its newest Series 9 and Ultra 2 Apple Watches, which contain pulse oximetry tech invented by Massimo. This ban is still in place and proof that the ITC can level the playing field for startups, even against trillion-dollar giants with billion-dollar legal budgets. But how can you access the ITC? What are its requirements? How can you afford it? And what should you be thinking about now to help future-proof your patent portfolio for the most effective use later at the ITC? We're answering all of these important questions in an episode that is part of our ongoing series on patent quality, aimed at not just getting a granted patent, but in having one that will hopefully be valuable and stand the test of time. Because experience is the best teacher, we've enlisted the help of Evan Langdon to guest host this month's episode. Evan is a partner at Fabricant LLP and the chair of its ITC practice. Evan has been focused on ITC litigation for the past 15 years, both offensively and defensively, having represented clients in more than 30 Section 337 cases at the ITC. Evan is recognized among the nation's top ITC practitioners by Chambers USA and Chambers Global. Evan is joined today by our always exceptional group, including Dr. Ashley Sloat, President and Director of Patent Strategy at Aurora, Kristen Hansen, Patent Strategy Specialist at Aurora, Marie Smith, Patent Agent at Brake Hughes Bellerman LLP, and yours truly. In addition to answering the questions mentioned earlier, Evan will also be breaking down the recent Lashify case and what it means for smaller startups, as well as unpacking the related domestic industry requirement and what it critically translates to for your business in terms of domestic and offshore spending and asset allocation, should you someday need to assert your rights at the ITC. Whether you're a solo inventor, small startup, licensing university, or even a giant in the making, the ITC is an approachable venue, and the insights Evan shares today could make all of the difference for future self. Now, before jumping in with the panel, we'd like to take you to the Mossoff Minute, a monthly segment that builds on our Patent Wars episode and features short conversations with Professor Adam Mossoff, providing updates and quick takes on movements in patent reform, significant court rulings, innovation policy happenings, and occasional Star Wars references. In this month's Minute, we're doing something we've never done before, and that's resharing a prior installment because some things are worth repeating, because this one is so very on point for today's topic, and because if there's something we can do to help address one of the major plagues of the patent industry, that's a drum we'll keep beating: This amazing tool of injunctive relief that you're going to learn more about today is fortunately available to some patent owners via the ITC, but is no longer available to most all patent holders in courts since the eBay decision. The proposed Restore Act is a potent new patent reform bill that aims to reverse this outcome in courts by restoring the rebuttable presumption that patent holders are entitled to injunctive relief upon finding of infringement. The ITC is still a favorable venue for patent holders to obtain injunctive relief via exclusion orders in the post-eBay world, partially because the Section 337 statute that governs it essentially says that patent holders are entitled to the presumption of the injunctive relief of an exclusion order, provided that blocking the import of the infringing product wouldn't cause public harm. In other words, the default framework for the ITC is a rebuttable presumption of injunctive relief. As a model, this rebuttable presumption has worked very well for inventors at the ITC, and Restore would be a very close analog for Article 3 courts. So, for anyone who says Restore won't work because the presumption is not enough, all you have to do is look to the ITC for a functioning example of why it will.
The big news in patent policy is that the Restore Act was introduced in Congress on July 29th. Restore brings back, it restores the original doctrine that had existed in this country from 1790 until 2005, that a patent owner receives an injunction on finding of infringement of their property rights, continuing ongoing infringement, that can have defenses applied against it, but that the general presumption, in the law it's called a rebuttable presumption, is that you receive an injunction for continuing infringement. This was changed in 2006 by the Supreme Court in eBay decision, a very famous decision, or infamous. eBay, as a result of changing the law, creating a new four-factor test, has made it much harder for patent owners to obtain injunctions. New research shows that well over 90% of infringement for patent owners who license their patents, and even patent owners who manufacture their patents, 2/3 of them are unable to obtain injunctions. This has devalued patents as an asset class in the innovation economy. It has made it much harder to commercialize one's innovations in the innovation economy, because people now know that they can take your inventions and they can use them without being held accountable. This is the same problem you would imagine if you own a house and someone could sleep in your bedroom and you couldn't kick them out, because that's what an injunction gets you. Of course, that would devalue your house if you tried to sell your house or to use your house for other purposes. And the same problem has been facing patent owners since 2006. And the Restore Act will change this law, restoring us back to the original doctrine that drove our innovation economy, that made the United States a global tech leader and secured us against global competitors like China.
Thanks, Adam. We're also publishing clips from the Mossoff Minute as short-form videos on Instagram Reels, YouTube Shorts, and TikTok. You can check out these shorts and follow us at Aurora Patents on all 3 platforms. And now, without further ado, take it away, Evan.
Well, welcome everyone. We're going to be talking about the ITC and some strategic avenues to getting there and being successful at the ITC. Just by way of background, my name is Evan Langdon from Fabricant LLP. I've been practicing in this area of ITC litigation for well over 15 years and litigated dozens and dozens of cases, both offensively and defensively. So we're going to kind of walk through some of the things that smaller companies to mid-sized companies should be thinking about and looking for. Also some tips for patent prosecutors in crafting patents to make them a little bit more friendly and advantageous for your clients to utilize the ITC. So I'd like to start off with a little bit of example, kind of just to home us in here. And if you're an inventor or have been in the patent world or have turned on the news starting anytime from last Christmas till now, you'll likely have heard of the dispute between Massimo and Apple involving Apple's newest watches, the Series 9 and the Ultra 2. And the reason I'm bringing that up here is because it's relevant to our discussion today. That dispute took place and was litigated before the International Trade Commission, which I've introduced as commonly known as the ITC. Just give you just a brief overview here to what we're going to be discussing today. I'd like to get into what is the ITC, some of the advantages of it. I'm going to spend some time talking about the domestic industry requirement, which is really kind of the barrier to entry, if you will, to bringing your case to the ITC and taking advantage of all those all those advantages to the complainant. And if we have some time, we'll just briefly touch on a little bit of litigation financing, which has found its way into the IP litigation space and also into the ITC. That makes it a little more reachable for a lot of entities. So before we go any further, just a little background on the ITC. It is an administrative agency. It is tasked by Congress with protecting domestic industries from unfair competition and unfair acts, which are connected to foreign imports, which is a bit of a mouthful, but predominantly it is a forum for patent litigation. That is the unfair act that is litigated almost 90% of the time. And a lot of products in today's economy are imported from abroad. A lot of products are manufactured abroad and imported in the United States. So those factors are not to say easily satisfied, but are satisfied in a large majority of cases. Now, like I said, it is a trade remedy. It is not an Article 3 court. And so it is, by statute, it is trade related. And that means that the primary relief that you're seeking isn't money award, isn't monetary damage, it's injunctive relief. So practically speaking, the ITC is useful to patent holders and inventors because it provides what the district court no longer can provide in the wake of eBay, and that is injunctive relief to stop the infringer from importing infringing goods. You know, a lot of big tech, and we'll pick on Apple because we have that as an example, going back to the Massimo Apple case, have been kind of coined what are called willing infringers, the catch me if you cans. They can go to district court, drag out that case for years, and if you catch them, they may owe monetary damages, but you can't stop them. You can't truly enforce what you should have, which is a monopoly on your patents for a limited period of time. And we go back to this example because the reason it garnered so much attention is because that injunctive relief. Massimo prevailed and obtained an order preventing Apple from importing its infringing watches. Huge win for a smaller company compared to Apple. Almost any company is a small company compared to Apple. But the two Apple watches that issued there were found to have blood oxygen sensors that infringe Massimo's patents. And we can get into the details if we want, but the bottom line is that smaller company, Massimo, was successful against a tech giant, and it was able to use the ITC to hear its dispute. That isn't to say that throughout that litigation, Apple didn't pull out all the stops, because it definitely did. And even once it lost, it petitioned to U.S. Customs and Border Protection seeking a stay of an exclusion order. It sought relief from the Federal Circuit. Ultimately, the Federal Circuit denied those stays, and Customs determined that Apple watches without the infringing features could be imported. And that is the ban that is currently in place today. You can get an Apple Watch, but it does not have Massimo's technology on it. So what does this all mean? It means that Massimo successfully enforced its right to a limited monopoly to enforce its patents, and Apple can no longer use that technology unless under license from Massimo. So huge win for patent holders and inventors. Massimo's experience proves that patent protection can level the playing field, and the ITC helps to do that even against tech giants such as Apple.
I have a quick question for you. If you're bringing a litigation suit of some kind and you could get some sort of relief with the ITC, do you bring a case in tandem, in parallel, before you start a litigation? How does ITC practice work?
That's the same question, Kristen. Good one.
Yeah, that is a good question. That is the general strategy, is to bring a parallel case in district court. And you typically want to file that simultaneously or within a short period of time after the ITC. And I say after because this is where some strategy comes in with the PTAB. You know, you don't want to get involved in IPRs. When you have a district court case, the number one move is to file an IPR. Get that clock going. A lot of times you can then petition to stay the district court and let the PTAB, hear out the invalidity side of the case. And typically, the numbers are pretty high in favor of petitioners in that case. At the ITC, once you file that case at the ITC, you file the parallel district court, the ITC will not stay a proceeding in view of a parallel PTAB case or parallel IPR. They'll both continue on parallel courts, on parallel paths. The ITC typically will finish first. So it effectively neutralizes the threat of an IPR or the effect of a PTAB. If you're at the ITC, it moves too quickly.
Okay.
District court case, because obviously if you file two lawsuits, you're worried about costs. In most cases, predominant number of cases, the district court case is stayed in view of the ITC. And the reason I say predominant and not 100% of the time is it is statutory and it is automatic, but it's controlled by the defendant. Whoever is a defendant in the district court and a respondent in the ITC, they're the ones that can move for the automatic stay so as not to drag into two fora and multiply the costs. Like I said, it's entered into most of the time. Some of your multinational, multi-jurisdictional cases that already have multiple components going on, sometimes maybe they like the forum they're in for district court or want to keep things moving in parallel. So there's a small percentage of cases that do that, but that's a great question. And that's the typical strategy.
Okay, thank you.
Yep. So that brings us into, well, what are the advantages and why do complainants want to use the ITC other than, I want to be like Massimo. And the reasons, I have, are about 4 of them. The primary reason for bringing a case to the ITC is its speed. In fact, speed could probably be listed as reasons 1, 2, and 3. The primary measure in determining leverage in any IP litigation is time to trial. The primary measure of success rate is time to trial. And the ITC time to trial is about 9 months, 9 to 10 months. This is faster than virtually any district court. So because of that speed and following your question, Kristen, that does avoid the PTAB. And so the interplay between the ITC and PTAB it favors the complainant here. And not only that, the commission generally prefers to reach its own decision on patent validity. So in the rare instances where the PTAB does come out first, the ITC will sometimes defer to them and stay their enforcement, but not their ruling on the case. So it is an interesting interplay, but it still favors bringing the case to the ITC. The other, another factor that is, which we touched on, is that injunctive relief. Again, going back to the eBay factors, which are not required here. No need to show irreparable harm if you have in the district court. The ITC remains the only forum where injunctive relief is readily attainable upon a finding of violation of the statute, which here would be patent infringement. The other reason is flexibility to address and name foreign entities where sometimes it's hard and difficult to drag them to district court. A lot of times you have foreign entities that don't show up. You can't attach the claim to them. There's nothing to collect, but you can prevent them from importing the product into the country. I can tell you in my experience as an ITC practitioner, unless it's a very small foreign entity that has minute sales is going to default, most of those show up. Most of them do not want to have the United States barred as an area where they can make their sales, right? The market is just too big for the United States. And finally, one that is not often overlooked, but I think is getting a lot more attention, is the jurisdiction and joinder rules. A complainant can name as many parties as it wants in an ITC proceeding. I've seen up to 100. Not advocating that. It starts getting a little bit crazy with logistics and cost and moving parts. But it does provide you, if you have 5, 10, 15 defendants that are infringing, they all have pretty good market share. You typically run into the problem in district court of what jurisdiction. Am I going to be spread across the country? Am I in 2 in Texas, California, Delaware, New York, Florida? You can consolidate and name all of these parties in one ITC action, and you remove the ability to get transferred. There's nowhere to transfer to. There's only one ITC. There's no venue disputes, no transfer motions that allow us experience to Northern District of California, where a lot of tech companies are related. And there's no equivalent to Rule 12 at the ITC. So there's a lot of advantages procedurally that put the ITC as one of the predominant fora you should be considering. And I can't stress this enough. This is one of those things that if there's only one thing that is taken away from our discussion here today, is bottom line, the U.S. market is still a leading market, and with the leverage the ITC provides to complainants, if you're able to establish domestic industry, which we will talk about, and the U.S. market is of primary importance to your client, which it typically is, then the ITC should almost always be a part of your overall litigation strategy, if not the predominant force in your litigation strategy.
Evan, in terms of that second point there around injunctive relief being automatic, we've been talking a lot lately around injunctive relief being broken really since the eBay decision. Why don't the 4 factors apply in this context?
The 4 factors don't apply because, again, it's a trade statute, and the remedy is to provide relief to the U.S. consumer. You're trying to protect the U.S. consumer. And it does have statutorily public interest factors. And once a decision is found by the judge, the administrative law judge, that there has been a violation, at that time, typically at that time, but it may also be throughout the case, evidence is taken on the public interest. And what the determination is whether or not the imposition of the importation ban is going to have a negative effect on U.S. consumers at large. Right. So, and also, there's a couple of factors that I have to look at in there. Is there going to be some sort of negative impact on consumers, such as in the medical industry? One of the most common examples of this, and this is probably 30 years ago, 25 years ago, there was a case that involved hospital beds for burn victims. And it helped, to move the burn victims, which obviously are in a lot of pain and you don't really want to touch them, but, you don't want to develop ulcers and things of that nature and the wounds. So it was a mattress that helped move the burn bed victims. Well, there was an ITC case. The product was found in violation. However, there were no replacements on the market. This would just be taken out of hospitals, and the consumer, or burn victims to be exact, because that was a consumer that was defined, would have been harmed. So that was overturned, or not to say overturned, but not enforced. And so you have some examples like that. So the public interest factors at that stage when a violation has been determined are evaluated. And then there also is a presidential review. So if it makes it through a violation and the public interest factors are found that if enforced, it's not going to harm the public at large, then the president via the U.S. Trade Representative can also look at that 60 days after all that is done to take a look if there's any policy concerns in terms of overturning or not enforcing the order. So those are the things. That's why eBay is not a player, because Congress via the statute has kind of already outlined a way to protect the U.S. consumers.
Right. So like under 337, then the default presumption is if infringement is proven that an exclusion order is warranted by.
That's correct.
How do you get out of this if you are importing something that has an injunctive relief come out from an ITC case? Other than like Apple did, Apple removed a couple of the features so that they could still import part of their product. How would one get out of this or get this reversed or overturned without going back to the initial case and the initial ITC setup, who makes these decisions and says, well, it's public interest to allow this to still import? How else could you get out of that?
You mean via the litigation? Like how strategically defendants or respondents in this case work through the case?
Either work through the case or work around the import ban.
So a couple of things. One, you could not import. So that would be reshoring. If you're manufacturing abroad, then you could reshore. Now that isn't available to most entities, because a lot of them that are considering this have some sort of contract manufacturer, but one would be reshoring. Two would be a design around. And one of the strategies, you have about 5.5, sometimes 6 months of discovery, is to design around and get that new design in the case, so the judge can rule that it's not infringing and you have a path forward. That's typically depending upon what the product is and if it's possible to do that. You see that in consumer goods cases, depending upon how the patent is written, how narrow can we change a feature? What is that? How fast can we get that done? And I've been successful with some of our clients, and before discovery is over, sometimes even before the judge needs to rule on it, the other side says, okay, yeah, we'll settle out as long as you only go forward with your new design, something along those lines. So design around is definitely a key, and you definitely want to do that during the case. If you fight the case, and here's why, if you fight the case on your current design, and then afterwards go, okay, we lost, let's design around. Well, you're now no longer in front of the ITC and the judge, you're before customs. And it's a much more difficult avenue and much more expensive to take that design, bring it before customs, have them look at it, decide a ruling, then modify the exclusion order. And all the while, you're not importing any product. And that process can take as long as an ITC case. Sometimes you're looking at 9-10 months. So you really want to, if that's one of your avenues, it's not saying you have to admit infringement. You're just putting in another product. I always say, hey, you got 2 products, let's make it a 3rd product and make it a design around and see, hopefully we have a path forward. Like, keep your options open as a respondent. The other obviously is reach out, try to find a way of settlement. That's in any case. You can unilaterally get out of a case by taking a consent order or voluntary default. But what you're doing is saying, I'm not going to participate in this product in the United States market. So you can get out of a case. And if you're a small party, or depending on how large, we started talking up with Massimo v. Apple. There's a lot of cases out there where the complainant names 10 people. There's 2 or 3 main targets. There's 5 or 6 that are small, and 2 or 3 really small that happen to get swallowed up in it because they make an infringing product, maybe on a lower margin or inferior in terms of quality, that get wrapped up into it. And they said, hey, no mas, I just want to get out. How do I do that? And that is an avenue for that, to do that as well. Obviously, the last one is to invalidate or to actually litigate the case, invalidate or prove non-infringement of a product. But it's tough to get out unless you're willing to take one of those. Avenues. So we've kind of covered some other points, and I just want to make sure we've hit them all. And one of the questions that I receive from clients or potential clients is, with the absence of damages, the ITC, why do I want to bring a case here? Like, how does that, and I get other practitioners or sometimes on these panels, like, how does that affect client decision-making on whether or not to utilize the ITC? And the short answer is it really doesn't. And if anything, we have the discussion that we've had here today about injunctive relief and the absence of obtaining that in district court, and that the sole remedy the ITC offers is that injunctive relief in a shorter period of time. And from a strategic ability, it allows you to apply a real pressure that you can't get any other place. So it's not really an absence of damages issue, but rather the fact that the ITC provides that injunctive relief. And if anything, you may realize those damages via settlement or license sooner than you would if you brought it in the district court. We said, Kristen, following your question earlier, general strategy is to file that parallel district court action. So in the back of their mind, they know that, if I decide to take a consent order, unilaterally get out, I reshore, I get a redesign approved, I still have a parallel district court action that are going to come after me for past damages, right? And so if you are successful with the ITC, you can port over the record to the district court, and it's persuasive, it's not controlling, but for the most part, most district court judges are not going to relitigate a case that has a claim construction and finding of infringement in it on the same products. So it's strongly persuasive, and district courts can follow it via the Federal Circuit ruling that they can. They're not obligated to, but they can use that as a basis of the ruling. So that is the general strategy, and typically it doesn't get that far once you have a violation and the import ban in place. Oftentimes that discussion takes place, right, of settlement. In the example of Apple v. Massimo, when you have a software case, and there's software implemented on the product and they can remove the infringing software, you've won, you've got your injunctive relief. You can then go after the past damages for using that. But if they're willing to, continue like Apple is bring in that product without the infringing software, then they can do that. So I guess that's one way of getting out, depending upon the product at issue, technology at issue. So we've talked a lot about the benefits of going there, and that all sounds great, but it's probably time we start talking about how do we get there, right? How does a patent holder bring a case to the ITC? There's a lot of nuances to everything we're going to talk to today, but at a high level, there are three main components. One, there must be an unfair act, right? Common example, patent, trademark infringement. Like I said before, about 90% of cases are patent. There's trade secret now taking up a good number of cases, and trademark is in there. Typically, trademark or some of these other Lanham Act cases are in addition to the patents that are right. Not usually as a standalone Lanham Act case, but you have your patent infringement. Sometimes you'll have false advertising, trademark infringement on top of that, on top of the patent infringement claims. The second component is that the infringing product or the accused product must be imported into the United States. This includes product being imported. If the entity is selling for importation, that would fall within Section 337. If it somehow was imported and another party is selling it after it's imported, they're subject to 337. And this is a relatively, I don't want to call it a low hurdle, but relatively, because it only needs to be one sample of importation. You don't need to show a certain volume. The product should be manufactured here, exported for whatever reason. Software gets put on abroad, a component is added, and then re-imported. Once it's been imported in any way, shape, or form, it's under the jurisdiction. I've seen contract, or there's case law on contract for importation, and you're probably wondering why you want to bring a case where there's only one product imported, or just even a contract of importation. Think of large products. Think of tractors. Large machinery that there's not typically large volumes of sales per year. Those are where these types of kind of nuanced importation arguments come up. Recently, and it is still not, I shouldn't say it's still, but recently the commission and the Federal Circuit has affirmed, it's been recently challenged to the Federal Circuit, is the time of importation. That was a big deal 5-6 years ago, and the commission and the Federal Circuit has blessed this, that they've now separated the importation requirement from the infringing analysis. Before, it must be infringing at the time of importation. Well, that brings in a lot of issues of if two things are combined once they're imported, software is added once it's imported, sold to a client and they turn it on, it wasn't infringing at the time of importation. Now those are two separate inquiries. Was the product imported, or was a component of the product imported? At the end of the day, the product being accused doesn't infringe. That is currently being challenged at the Federal Circuit in a number of different ways and cases, but largely under the Lopper decision that has kind of opened the door for some new appeals in terms of whether the commission has authority to interpret its own statute and things of that nature. But I think the cases up there aren't the right cases to change that law. So right now, that in my mind, that's going to stand as the standard there for importation and timing of infringement and importation. The third element is the domestic entry requirement. And this means, and we'll spend a little bit of time talking, because I know it's of importance to a lot of inventors out there, and it really is the biggest hurdle to coming into the ITC is, do you have patents that your own products practice? So the domestic entry requirement is one of those procedural nuances unique to 337, and it could be a major speed bump, minor speed bump, or a major hurdle to a complainant. Most of the time, it's a minor speed bump. If you have products and you have IP that you've developed in-house, you're trying to draft that IP to protect your products. There are essentially two main components. The first is called the tech prong, which requires the complainant to show that it has a product or products that practice the patents they're asserting. So in other words, a complainant must show, as I said, that its own product practices, and for lack of a better term, they basically do an infringement analysis of their own product to show that they have products in the United States that practice their IP. All right, that's the first hurdle. And this is where we kind of just want to throw in a note here for patent prosecutors, and where you can kind of come in on an ITC strategy. For asserting patents, the ITC, you need to show, like I said, your patent practices, your product practices, the patents you're asserting. It does not need to be the same claims that you're asserting for infringement. So you could have 25 claims, 20 claims, whatever. 1, 2, you can show that your product practice, and the other ones are directed towards, broad reading, and some maybe are directed towards specific products. So as a strategy, you want to have claims that are narrowly read on only your product. So the idea is, for certain you have at least 1 or 2 claims that read on your product, right, to satisfy the domestic industry requirement of the ITC. Also, by narrowly drafting it, you're going to avoid invalidity, right, or hopefully avoid invalidity. So it's kind of twofold. You have a direct avenue to the ITC, and you're trying to strategically avoid that claim being invalid. Typically, you're thinking, well, if it's that narrow, it's not going to infringe where I'm going at. That's not what you want it for here, right? You want to set aside a couple claims just for the ITC. So after you've overcome that hurdle, the second is known as the economic problem, which focuses on complainants' economic investments in the United States in those same products that were shown to practice or patents. And this is where it gets mirrored up. So you have your products, and you may have 10 products, but maybe only half of those practice the patents that you're asserting in this case. So you've done your analysis and you've shown that. Now you need to show your United States investments only in those 5 products, right, that practice the asserted patents, to show the economic investments in the United States to satisfy the economic prong. And this is where some respondents, and actually I've spoken on a few panels about this, about the interplay between the technical prong and the economic prong, because it sounds simple, and it is, but when you have multiple products and multiple patents, and not all patents practice the products, or not all products are practicing each of the asserted patents that you're asserting, you can get into kind of a crazy Venn diagram, if you will, of which of your investments can count towards this patent versus that patent, and you got to keep things straight. There is a recent case, Lashify, at the ITC, and it's being currently appealed at the Federal Circuit, and that is one of those cases where it had multiple products and actually had systems of products, or they sold products individually, and they sold them as a kit, lash kit, an application kit, and things of that nature. But the patents weren't drawn to all the pieces of the kit, and they weren't drawn to all the other components. So when you start separating things out, they started having to not discount, but allocate their investments only to certain portions of the products that they were claiming, and ultimately were unable to do so. I do believe that if they had found a way to track the investments by products a little more closely and tie them to the specific patents, that is a case that has provided a roadmap for smaller entities, a lot of entities that work out of their garage, small companies. Inventors like to say put a lot of sweat equity into their case before or into their product or their company before it takes off. Even though the Lashify complainant was unsuccessful with the ITC, the case law that's come out has provided a nice roadmap for small entities to develop their case.
Evan, real quick so remind me, it has to, your products need to practice your patent, and then you can then also assert then for the ITC, that has to be the same patent though. So when you say like crafting claims, you should have claims that are broad enough to capture would-be infringers at the ITC, but also some that are narrow enough to cover your own product, but all in one patent, right? That one patent has to be able to do kind of double duty.
That's right.
So one patent to do one and one patent to do another, right? It has to be all in one.
Right. So if you have 5 patents, all 5 need to have a claim that you can map to your own product, right? And then obviously all 5 have to have at least one claim that is found to infringe. Now, it can be the same claim, and oftentimes it is. It isn't a requirement. You're like, hey, the only way to do this is to have some standalone claims that are drawn onto your product. It's often the case that it's a complete overlap between infringing claims that are served for infringement and claims that are served for domestic industry. Just as a strategic note, if you are thinking ahead, it does behoove you to have a narrower claim that can satisfy potential any invalidity challenges and that reads on your product. And the reason it needs to satisfy invalidity challenges is because just like infringement, you can't have domestic industry on invalid claims.
Evan, with Lashify, it's my understanding that they successfully proved infringement, but one of the other issues was that well, they had a successful product in the United States and they had like 100 employees or something like that here. All of the employees were engaged in marketing and sales activities and not in engineering, research and development, or manufacturing, that they were doing all of their manufacturing overseas, and that the ITC sort of has like a present bias towards, manufacturing and development that's happening onshore versus strictly importing with only sales and, marketing activities onshore. Is that an accurate read?
Yes. I'll speak to that. So the ITC has what they call the mere importer test, and it's been around for a while, but with Lashify and a couple of subsequent cases has really garnered interest with the commission itself, and the case law has really kind of been refined. And the mere importer test at a high level is if you're performing activities of only a mere importer, you're not going to satisfy the domestic industry requirement. So at a high level, a mere importer would be someone who just contacts a manufacturer in, let's say, Asia and buys a product off the shelf, already made, packaged, ships it into a warehouse and sells at a warehouse. You're doing nothing more than mere import. You didn't invent anything. You didn't develop it, research on employees, etc. So it's been broadened that only your activities you have are that of a mere importer. So that would be sales and marketing, advertising, things like that. Those cannot count. And I say cannot count because I typically try to cut those out to avoid the argument and, like you said, the present bias of the commission of including those, because some commissioners are flat out no, and some under the statute and legislative history says that you may be able to count those, but typically you can count those when you have other factors, other investments in manufacturing, other investments in R&D. And practically speaking, if you have those other investments, you don't really need the sales and marketing investments. So for the most part, yes, that is a red flag. If you only have sales and marketing investments, you need to have something else. What largely happened in Lashify was their current investments at the time they brought the case were largely, they didn't accurately capture some of their past R&D. And so if you have a small company such as Lashify and you have R&D, research development, sweat equity out of your garage, maybe you hired an engineer who did some work for you here, then you went and hired another one. It took you a long time. Then once the machine got going, right, the company got off the ground, there's less R&D and more in sales and marketing. That can be argued to be successfully a domestic industry because you just need to show in this industry, this is where the examples of the marketplace at issue, that they did the investment, right? They did the initial investment, and now it's like, what are the sustaining activities they're doing now? What are they relying on now? And so it can start swaying from a high level R&D and low levels of sales and marketing, and then kind of swing their days, low levels of R&D and high levels of sales and marketing, as long as you're able to capture some of that in that previous research and development activity. So again, when that case had, like I said, that Venn diagram of various products, when you start cutting it down, some products had more sales and marketing than others. And so it looked like at the end of the day, when you were all done, the ones that kind of made it through infringement and those patents were found valid, the expenses that were left were largely sales and marketing, and that's partially why that case was unsuccessful from a DI perspective. But there are ways of putting it together and capturing some of those past investments and showing the development of the company and what they're currently doing now to be successful at the ITC.
So Evan, I'm sure this is kind of subjective, but like when you say significant or substantial investments for like a startup, what would that look like? Would that look like, tens of thousands of dollars into a patent portfolio with maybe a single product and, maybe some small sales? Like all of that would be included, and, what would be like the bar?
Right.
Right.
Right. So anyone the ITC would tell you, and the case law will say that it's not supposed to be an accounting test, and there is no magical bar, magical number, right?
Okay.
Without going too far into the weeds on the economic problem, there are two main things they're looked at. One is you have to quantify the investments, right? So it's numerically how much money is being spent on activity, overhead. We can, on the investments. And this could be how much money is spent on employee salaries to design, develop, engineer, manufacture, assembly the products. It could be the rent or mortgage payments for facilities where these activities take place. It could be the cost of equipment to use, in the design, development, engineer, as long as the investments take place in the United States. Now, it is very common for a product to be manufactured abroad and imported, right? That isn't unheard of, and it's also not a hurdle that can't be overcome at the ITC. So to your question, how much money? It really is. This is where once you quantify, there's also a qualifying, the qualitative factors they look at. And this is, you look at the investments and showing what is the importance of these investments to this company's business or in the context of relative industry. So if you only spent $10,000, but that's the entire company, right? That's going to show significance. You only have one product, and everything you've spent is going into this one product. And without this one product, you would not have a company. That's going to be a qualitative factor. It's going to show this is significant to you. This is significant to the product, the investments you've made, as opposed to, let's put on the other end, you have a big multinational company and they spent $10,000, right? That is probably 0.0000001% of importance to their company, right? Or it wouldn't it be if you take this product out, that company's falling apart, right? So they would have to have a bit more of an investment, and they'd have to show, some sort of qualifying investments and show that significance. The other way of showing it, and this is one that's really taken on importance, especially from the commission's perspective, they want to see, especially when you have this dynamic where we had some investments in research and development, we're obviously shifting a little bit more towards marketing because we're trying to sell our product, and we manufacture abroad. How much money are you spending here in the United States versus how much is abroad? Okay, so if you're spending 90% on the manufacturer, you're going to be in some trouble, right? If you want to get somewhere in the sweet spot of 35 to 50% of your investments are here in the United States versus what's being spent abroad, right? More north of that, I start feeling more comfortable. That's kind of how I advise my clients. There are some cases where they say, something north. The only benchmark really is 5% is not enough, right? So
Okay.
because most of these numbers aren't public, and so
Yeah.
that's the only public number out there. I can tell you there's cases that are definitely between 5 and 30 and 35. But if you get in there and you can make this comparison between what you're doing here versus abroad, that's another factor. That's another way to qualify those investments to show that they are significant.
Okay, that's much more reasonable, I think. I mean, when you see a statute like that says, well, it has to be substantial, you tend to think, okay, I'm a small startup and this wouldn't apply to me, but that's not true. So this could be for startups, this could be for large companies and medium companies and single inventors if they have poured their money into a single product. So good to know.
Yeah, the other, the overarching standard that is kind of for significance is the realities of the marketplace. So if it's a marketplace that is like for a startup and the product is relatively new, evidence of well, what are others in the industry spending? We're outspending them, or we're on par with them. Like we're making a significant investment here. So there are multiple ways to show it. I'm just trying to go over some of the more popular, more successful, and ones that are directly more applicable to startups, which I understand are the ones that are a lot of which are concerned with that domestic industry analysis. There's also one important wrinkle to all of this, especially when it comes to domestic industry and startups, is that complainants can rely on the domestic investments of one of its licensees. So there are a number of factual scenarios where this comes up: smaller companies or inventors or startups that have licensed their IP to another entity or even a competitor in the industry. Right? Universities or R&D only companies that have licensed, right, their intellectual property. And more recently, non-practicing entities that have licensed their IP to practicing entities. So practically speaking, the complainant, whether it be a startup, which I've represented, whether it be a university, which I've also represented, they have licensed, they can step into the shoe of their licensee and show now the licensee is the party you're looking at for the licensee's products that practice the patent, the licensee's investments in those products to satisfy the economic prong and the technical prong of the domestic industry requirement. And so you're seeing a lot of those cases, like I said, falling under any of those factual scenarios at the ITC to, again, try to open the doors for smaller inventors. I'll say non-practicing entities because universities are a non-practicing entity. And we've recently seen universities take their cases to the ITC for enforcement when they're having difficulties with their tech transfer offices trying to license their IP. So that is a very powerful tool for complainants, especially in the, like I said, the startup or smaller space. So strategically, that is something that a startup can do, is find a licensee partner, right? Not necessarily an investment partner, but a licensed partner. Obviously get some income stream coming in from them to continue developing, but obviously can help potentially open the doors for the ITC for a larger enforcement campaign.
Evan, is there any magic language in licensing contracts that you would need to have to be able to use that partnership in that way? I just think of, like assignments and things like that. There's some magic language, or is there
No, there's no magic language, just making sure that they're licensed to the patents, right? So you don't want, a lot of times, just make sure they're licensed to the patents that you're asserting, right? That's the biggest deal. Like any license, there's give and takes with what's negotiated. But, oftentimes if you have, listed patents and the portfolios are still open, continuations includes those anyway, right? So then down the line, the continuations are the ones that you're asserting. So, make sure they're covered. I have seen language in license agreements that obligates the third party to participate in the ITC case. That's not required. It's not necessary. There's some companies that don't want to be the third party domestic industry, which is what is commonly referred to as a third party domestic industry. But many of them participate and provide, the necessary information to satisfy that. But there's more and more you're starting to see strategically companies saying, hey, as a negotiating piece, I want you, I'm going to bring an ITC case. I want you to be the domestic industry. There may be some compensation for that, in terms of other terms of the agreement. But it's not required, and there's no magic language necessarily.
But it would be, if you have a partner, a long-standing partner, they wouldn't have to participate though. So if you want them to have to participate, then your contract should obligate them, right? Because they wouldn't, if you decide to bring action and you want to work with them on that, they don't have to participate though, right?
Well, you subpoena them for the information.
Okay.
I think it makes for a much happier environment, if they are participating. And a lot of companies are okay. We reach out to them, say, we're going to bring this suit. We're going to subpoena you, largely so. Everything you provide under the protective order, maintain your rights. And even though it's via subpoena, it's a very harmonious, relationship. It's not adverse. I think some of The bigger tech will say, hey, we don't like this practice. It allows these non-practicing entities, to license and establish domestic industry and go after us. We got to kill this practice. We have unwilling third parties, and that's not really the case. I mean, not to say there hasn't ever been an unwilling party, not necessarily happy about being the domestic industry, but it's not what is being portrayed. Yeah, thank you.
Okay, perfect. Thank you.
So I'm not sure how we're doing on time here. What I was going to flip over to was just discuss a little bit of litigation finance and how it's growing in the area of patent litigation, and it's found its way to the ITC. So like going back to like the Massimo Apple example, and I don't have any numbers in the cost of litigation, but I can tell you it was not inexpensive, right? Not all ITC cases are going to be as large or expensive as that case, but there is a cost to litigating patents, and there has been an increase in litigation financing in the past 5 to 10 years, and even more so in probably the last 3 to 4 years, even more so in the last 2 years. It's just a continually growing industry, and it has allowed patent holders, big and small, to bring district court cases, ITC cases. And what has been popular as of late is multi-jurisdictional campaigns. We have a district court, ITC, and potentially another jurisdiction outside of the United States. But obviously that can be expensive. It's also a way for companies that may have the cash flow to de-risk investing all their money in litigation. No one, some of these cases, it was like a bet the company case. Well, it doesn't have to always be a bet the company case anymore. It can be a good portion of the company, but you can de-risk that. Obviously, you're capping your upside a little bit, but you are lowering your downside to zero. A lot of these are non-recourse loans from a funder that if successful, they're going to want a percentage or take home a percentage of the ultimate relief. If not, it's no recourse to the plaintiff. So it is something for startups to consider, for sure. Small companies, if the small to mid-sized companies that have the IP, that have a strong case and the damages are large enough, is definitely something they should be considering. And the ITC, because of all its advantages, has been a forum where cases are being asserted by smaller entities or even mid-sized entities that are backed by legal funders. It's been one of those things that's led to diversification of legal providers, more boutique firms, specialty firms that specialize in either legal litigation finance or ITC litigation, or even those who are part of larger campaigns. And some firms combine or co-counsel depending upon which part of the campaign is being handled by that firm. But not a lot of times, but growing number of times that litigation is backed by litigation funding. Not to get too many weeds on that, but a lot of questions I field from startups, small company, mid-size is, okay, that all sounds great. The ITC sounds good. You sold me on that. I understand how to craft my patents. I understand what I'm looking for. I think I understand what needs to happen on the economic problem of domestic industry. Yes, money sounds good. So how do we get that? And so, we spend a lot of time evaluating cases, whether or not, the client's traditional hourly rate or whether it's going to be funded. And there are certain things that funders do look at in determining whether to fund a case. And, one of those is a lot of times what we look at, time to trial, very important in these cases. So ITC, jumps to the top of their list. Eastern District of Texas, Western District of Texas are things that they're looked at. The number of patents in the portfolio, the more diverse the portfolio is, reduce the risks of invalidation via IPR, unfavorable claim construction, invalidated during the case, non-infringement, obviously. The more you have, the more diverse you can be. The others, that are often looked at, age of the patents relative to the technology. And that kind of dovetails with realistic potential damages. You want a somewhat of a mature market, so you can realistically value the patents and value the patents in litigation, which are sometimes mutually exclusive things. And what I mean by value in litigation is, what are the volume of sales? How big's the company? Can they afford to pay for a license? What is a realistic ability to collect damages, to obtain a settlement fee or a license fee? Those are things that are looked at. Whether or not the inventor or company are still attached to the patent. That is very important to the funder and also to the ITC case. Patents that are bought, sold, you start losing the connect to the inventors. Now, establishing domestic industry, you got to dig in a little bit more and see what's going on. So that plays a factor. But those are kind of the threshold. And obviously, the realistic damages, the amount that varies from funder. They're looking for the value, the litigation value of the case to be, of a certain amount. And of course, the merits of the case, evaluating infringement and domestic, if it's ITC, you have infringement, validity, and then obviously domestic industry.
So you were kind of mentioning the age. I've heard that most litigation doesn't happen until like the last 5+ years of the patent. Is that pretty consistent with the ITC too, or are those cases happening earlier in the patent life, or what's that look like typically?
It's really technology dependent. I think a lot of software cases, bigger tech cases, pharmaceutical cases, those are in R&D stages long ago, and it takes a long time to get to market and then for the masses to pick it up. When you have more of a lower cost consumer product that can be adopted, manufactured, and put out in the market sooner, it doesn't typically have the same same life cycle. The patents are typically a little bit younger. Does that makes sense?
Yeah.
But on average, it's a good question. It is typically later. I would say the last couple of cases I litigated, there was probably only about 4 or 5 years left on the patents when we filed the ITC case. Sweet spot, I think, because you're also looking for not just past damages, but future damage. That 5 to 8 year is probably a sweet spot. Not to say that funders or even law firms won't get involved is under that, of course. But one concern at the ITC, if it's too short of a runway, we say 9 to 10 months to trial, but the case, if it goes to trial and it goes to commission review and it goes up to the president, you're looking at 16 to 18 months. So the patent doesn't have at least that left. You're gonna have problems asserting at the ITC, and really, you can't do 18 months because you get an exclusion order for 1 day, right? It needs to be 18 months plus 6 months to a year, right? So you need 2.5, 3 years left on your patent at least for the ITC to really have the teeth and have the leverage that we've talked about here today.
No, that's helpful. And so kind of, putting this, this has been awesome and super helpful. And I think it gives a lot of hope to inventors, especially in light of the being able to actually stop infringers. So from a practitioner standpoint, then the things that are, in thinking about how to craft patents to be best or like best practices for portfolios for ITC. I mean, it sounds like, continuations, you kind of mentioned diverse portfolios, maybe claiming things in lots of different ways, lots of different flavors, having like singular patents that cover a would-be infringing product and the actual product that you're from your domestic industry. Are there other key takeaways from like how can clients set up their portfolio now to hopefully be used at the ITC?
Yeah, no, I think you nailed the primary ones there. I mean, like any other litigation, keep the continuations open. You always want to keep yourself flexible. Been in cases where you put forth your strongest patent, the other side identifies a nuance, or you get a bad claim construction read. Well, file a track 1, right? Got some time left. You gotta keep your many arrows in the quiver as you possibly can. But the ones you identify there are the primary ones.
Do you think any of this is really going in the weeds, but do you think any of the more recent, there was the whole Sonos v. Google latches where, they should have prosecuted claims earlier. to make them more viable for district court. Do you see that impacting the ITC at all? Like, I've waited a long time to prosecute claims.
Yeah, latches typically is not a defense of the ITC because it's a forward-facing remedy. So, people try to make it a lot. Oftentimes the ITC, it just doesn't go anywhere because it's just not a remedy because it cuts off past damages, right?
Yeah.
And so you're not awarding damages in the forward-facing injunctive relief, so it doesn't really have any practical effect.
Okay. Awesome. That's fantastic. Kristen, Marie, Josh, anybody else have any other questions for Evan? And we really, really appreciate it.
Yeah, no, thank you very much.
Perfect. It makes me excited now. We get to talk about this more with clients.
Well, I appreciate you guys having me today. It's been fun. If there's any other questions, we can handle those. Otherwise, it was great talking with everyone.
Evan, we really appreciate it because we talk a lot about how there's a lot of different audiences for a patent over its life cycle, but a lot of times people are only thinking about getting it past the goal line at the patent office initially, and so we're really trying to have this quality series that's focused on what are all the things you can do to set future stuff up for success, and raise awareness to these other audiences for the patent. So this was so helpful.
Well, I appreciate that, Josh. Yes, I think that's a great thing that you guys are doing with your series. And I do follow that on IP Watchdog, and it, trying to broaden the audience, not really broaden the audience, and educate the audience, right? Like you said, I used to work at the patent office. I did prosecution for a while, and the goalpost should not just be right obtaining a patent to the that's the beginning step, right? That's in our football analogy. That's first and 10. We got a lot of ways to go to enforce that patent, and hopefully never have to, right? But unfortunately, in today's world, if it's a quality patent, quality product, you're going to have to.
Yep, 100%. Well, we appreciate what you do for companies because it's a good venue, and so yeah.
Great. Well, thanks everyone.
All right.
Take care.
Thanks. Have a good week.
You too.
Bye-bye.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.